We are live and on the record.
Welcome to the Appeals Court. I am Justice Mead. With me today are Justices Blake and Lemire will be your panel. If we run into any technical difficulties, we'll do our best to reestablish a connection that should it be lost, and no one will lose any time on their allotted argument, which is 15 minutes. We don't entertain rebuttal. With that, I'll call our last case, 2020 P153 Mancuso versus 263 through 269 Pleasant Street, LLC. Mr. Primison.
Good morning, Your Honor. May it please the court. My name is Webb Primison, and I represent Lisa and Philip Mancuso, who are the appellants in this matter. It is our position that the primary error made by the trial judge in this case was the finding that Chapter 48, Section 16 was not violated. And my brother, in his brief, has argued, obviously, that his position is that the statute was not violated for essentially two reasons. He says, as I understand it, first, that the remand, the manner in which this matter got back to the Zoning Board of Appeals, and the description of that procedure as being a hearing on revised applications means that the statute does not apply. Secondly, my brother contends that when a ZBA issues a written decision on a matter, and that matter is appealed, the decision which formerly was final suddenly becomes not final because it's subject to judicial review. I disagree with both of those positions, and I'll attempt to indicate to you why. The statute, as I know you know, is not designed to confer any benefit on a landowner applicant or to place any barriers before a landowner applicant. It is for the purpose of alleviating the requirement that neighbors, abutters, others who oppose the particular proposal not have to repeatedly go back to the zoning board and express their opposition. To me, when the land court in this case remanded the matter to the ZBA, whether you call it a revised application or not, it is clearly, in terms of substance rather than form, a second application. The representation was made to the court by the parties that they had revised plans and that these plans were believed to potentially satisfy the problems that the zoning board had found in its initial decision when they denied the special permit by a vote of 5-0. Well, since the reason presented to the court was that they have, in essence, a new plan or a different plan, that's the point at which we say Chapter 48-16 comes into effect. And that is that the planning board or someone else needs to look at the representation made by the parties and see whether or not the zoning board ought to rehear the case or hear the case on revised applications according to the statute. If my brother's argument is correct, then on remand, if this zoning board had, instead of issuing a decision granting the special permit, if they had again denied the special permit, then the developer landowner would have the right to appeal and potentially amend plans again with the intention of complying with whatever problems the zoning board found in support of their denial, ask the court for a remand, and go back to the zoning board of appeals, and could do this multiple times. And in our view, that is precisely the substance of the purpose of the statute, not requiring people to keep going back within a 2-year period to the zoning board to express their opposition to the application for the special permit. That's really my argument, Your Honor, in a nutshell, and what I wanted to emphasize in the argument today.
Well, Mr. Person, this is Justice Lemire. You agree the court has the authority to remand?
I do.
And the remand order of the court was that it go back for a full hearing on the case that they described, remanded to the board for a full, fair, lawfully noticed public hearing.
That is correct.
So they're complying with an order of the court.
Well, I don't see how, with all due respect, Your Honor, that a land court judge can overrule a state statute. In other words, if this is a new application, because it's clear that the initial application was unfavorably acted upon in the words of Chapter 48, Section 16. The May 2016 decision is unfavorable. Now we have a second bite at the apple, if you will. I agree, ordered by a judge, but there's nothing that in the judge's order or in any of the process that was gone through that would have prevented the developer, landowner in this case, from going to the planning board to seek consent. And it's our position that that's what should have happened. And that the judge, I'm guessing, but I'm not guessing that the judge ignored the statute. I'm guessing he expected the parties to comply with 4816, go to the planning board, and then if consent had been granted, go to the zoning board.
I have nothing further.
Mr. Feldman.
Thank you. May it please the court. My name is Paul Feldman. I represent the appellee 263-269 Pleasant Street. With regard to the applicability of 48 Section 16, put simply, zoning remand orders of a court, be it the land court or the superior court, are not subject to 48 Section 16. We have found no case in the Commonwealth that has held that a remand order in zoning cases that may result in a reversal of an initial unfavorable decision is subject to 48 Section 16. To do what Mr. Primison advances on behalf of his client is to alter decades of well-established practice by the trial courts in handling expeditiously zoning matters, and would be contrary to the Zoning Act and frustrate its purpose. So there are two portions of the Zoning Act that we maintain are in interplay here, Section 16 and Section 17. And Section 16 places effectively a two-year time bar on an applicant that desires to pursue a new petition for the same relief that was previously and finally denied. So I will get back to the term finally.
Let me ask you this, Mr. Feldman. If the initial land court Section 17 appeal had been finalized and the land court ruled theoretically that the board's action was appropriate and therefore denying the plan. You'd agree that if they wanted to submit revised plans at that point, they'd have to comply with section 16 and wait the 2 years.
Well, that's right. They would have, that's correct. Had there been a trial and the board's decision to deny the plans were upheld, the decision wasn't disturbed, unless that decision was further appealed to this court, it would become final. And once that decision was final under those circumstances, the only recourse for my client would be to submit a new application, presumably for a similar or different project or a completely different development of his land. So I would agree with that.
So essentially the parties agreed to avoid that by not going to trial and asking the court for a remand.
Well, in this particular case, very close to trial, correct. By an assented to motion, both parties went to the judge to say that they believe that it was in the interest of resolving this matter for the matter to be remanded to the zoning board for further consideration. And the specifics of what the judge ordered is set forth in the remand order in the record. But importantly, I would note two things. Number one, Judge Vey had to independently decide that that was an appropriate order of the court or an order that the judge thought it should be entered and under what terms and circumstances to enter the order. The fact that parties presented assented to motion doesn't make it necessarily an order until the judge independently determines it should issue. And the second thing we would say is that, and there is some speculation in the appellant's brief as to what was motivating the remand, but the fact of the matter is there's lots of reasons why, including a desire by the zoning board, after seeing how the case was going to be presented, to want to have another opportunity to further consider what they had done, because perhaps the zoning board was concerned about the outcome. So that procedurally is where we found ourselves. Both parties asked the court to consider remanding the matter for further consideration. The court determined that to be an appropriate order, an appropriate and equitable way to resolve the matter for the moment, and sent it back to the board.
What would have happened? What would have happened if the parties just, and again, this is off the record in the sense of this isn't what occurred, but what if the parties had instead said to the land court, Judge, we're going to go back. We've agreed to go back, so we're just going to dismiss this.
I think if the parties would have done that, or frankly, if the parties asked the court to just continue the trial because they want to go off and do something alternatively, the case would be before you in a different posture. That
I understand, but would Section 16 apply if it was dismissed and gone back under the same terms by an agreement?
I think there would be, well, you wouldn't have to have agreement of the parties to dismiss the case, and well, I guess you would at this point, but the point is, yeah, I think under those circumstances, Mr. Primison's argument would be completely different, and his reliance on the Remy case, for example, the Nantucket case, would be appropriate, more appropriate than it is in this context. If you recall, in the Remy decision, an appeal was taken of an original denial, and then the applicant chose to submit a revised plan to the board on his own. And as the court said in that case, not a bad position for that applicant to choose to do, didn't want to keep all his eggs in one basket on the appeal. But if that's what the applicant chose to do, then, as the court pointed out, the applicant needed to comply with 40A Section 16. So we think that it is significant, important, almost determinative that the reconsideration by the zoning board in this context was as a result of a court order by Judge Vey. And I would point out two things that I would disagree with Mr. Primison about what he just said. The first is that I don't know how, Mr. Primison said he was guessing. He was guessing that the judge expected the parties to comply with 48 and go to the planning board. I don't know why anyone would draw that inference. If you read the remand order that is in the record, the remand order says it was issued on October 10th, put notification in the Marblehead Reporter 2 days later on October 12th for a zoning board hearing that must take place on November 6th. And to properly notice that zoning board hearing, you need to get your 2 weeks of successive notices in the paper, so you have to start that by October 12th. The only inference you really should draw from that is Judge Vey had no expectation that there should be any activity in front of the planning board. But Judge Vey specified in his remand order what the parties should do. And I want to point out, as we noted in our brief, that this court has already held that a judge in issuing a remand order can vary from some of the statutory provisions set forth in the Zoning Act, notably Section 15. This court has already held that in a remand order, the judge can specify the timetable on which the board can act, and therefore things like constructive approvals and other things that the Zoning Act and the statute provides as a matter of law are not operative because of the broad power the legislature gave a court in 48 Section 17. And as you will note from our brief, that is really what's going on here. This court is being asked to reconcile and give meaning to all the various provisions of the Zoning Act and harmonize them. And it's easily done in this case. 4817 clearly gives the authority to Judge Vey that Judge Vey chose to exercise. This court has already said in exercising that authority, not every provision of the Zoning Act need be complied with. You've said that in connection with Section 15. And certainly, we would say it's even easier to come to that conclusion with regard to the repetitive petition provisions because, first of all, a remand is a continuation of the original proceeding. It is not a new filing. It is not a new petition. It is a continuation of an existing proceeding. And I would note, even though it was in a different context, in the Petrillo decision that we note in our brief, this court, in footnote number 9, was very clear to say that a zoning decision which appears to be final at one point in time may not be final throughout its time because it can be further considered. So when Mr. Primison says he doesn't understand how you can have a final decision that becomes unfinal, this court fully appreciated it and understands it. It's so noted and explicitly held in Petrillo in footnote number 9 that it was explicitly finding that zoning decisions do not have finality, and in that case it was for purposes of res judicata, because that finality is temporal and can change. What we would say, Your Honor, Your Honors, is that to alter 50 years, 60 years of the practice of the trial courts and the bar in such a dramatic way and limit the power and the authority conferred to the trial court judges to enter orders as justice and equity would require, to expeditiously have zoning cases move along by now saying, if there is an unfavorable decision, the only way that decision can be reconsidered by the board is either wait 2 years, or you now have to go to another board like the planning board, who has to now make an independent determination. All we're doing is creating more litigation and more uncertainty, and we can find ourselves in circumstances that a board like the planning board, that it was not a party to the case that was before the trial judge that was remanding decision, is now making decisions that can be inconsistent with what the zoning board ultimately decides, and we just have further litigation. We have unnecessarily and inappropriately complicated what is a well-established and known practice by members of the bar in the Commonwealth and the justices throughout the trial court system. We point to a number of other cases and decisions in our brief where this kind of remand has occurred without objection. I just want to mention to the court the case of Titcomb that we cite, because we painstakingly review how the posture of Titcomb and the appeals court decision, this court's decision in Titcomb, was exactly the circumstances that we find ourselves in, and the appeals court felt no need to consider the Section 16 implications, because I think it was obvious that Section 16 was not applicable in the circumstances, and this court should not make it applicable now. I know that Mr. Primison spent no time in oral argument on the second issue of appeal. I'm not going to, I have 59 seconds left. I'm not going to spend any time on it, just to note that the Judge Barrett's decision on preclusion board testimony was absolutely correct, and that issue has been waived, and there's no basis to reverse his decision on that score. And we would ask that the court also affirm Judge Barrett's determination that 48 Section 16 is not applicable in the circumstances of a remand order by a trial court judge directing a zoning board to further consider the original application under changed circumstances. Thank you very much.
Thank you. Thank you both. We'll take this under advisement.